On this Memorial Day, on this special 250th anniversary year of this great nation, it is fitting and well required to refresh truths about this republic, lest they be lost forever through ignorance or stealth. Strange as it may seem, of the three branches of the government of the United States of America, the judicial is the only one most people who live here understand. Everybody knows Supreme Court justices are appointed by the President and confirmed by the Senate. Pretty much everybody knows the lower federal court judges are likewise appointed by the President and confirmed by the Senate. How this works is set forth in what is known as the Appointments Clause of the Constitution. It is Article 2, Section 2, Clause 2, which is the executive branch. In reference to the powers of the President,
he shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur, and he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments.
Most people know how the legislative branch is elected. Elections for representative and senator are conducted by the states. What that actually means is lost to history.
The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. U.S. senators were originally chosen by their respective state legislatures until the passage in 1913 of the 17th Amendment, which provides for the direct popular election of senators.
The 17th Amendment states,
"The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as the legislature may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution."
That amendment changed the way senators are elected. It did not change what senators represent. The original method of state legislature selection established what senators are. Senators are the state's voice in the federal government. The Union. Senators, even though now elected by the people, represent the state from which they arise. The House represents the people. Election of representatives are outlined in Article 1, Section 1 of the Constitution.
The House of Representatives shall be composed of members chosen every 2nd year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature.
Senators serve for 6 years representing the states, while representatives serve for 2 years, representing the people of those states, within the district established for their election. These processes are fairly well understood. What is not understood is the different reasons the 2 levels of the legislative branch exist. Senators to serve the states from which they are elected, no matter how that election takes place, and representatives to serve the people of their specific district within those states. Perhaps the most important section of the Constitution having to do with elections is Article 2, Section 1. States conduct presidential elections. This section establishes the right of the states to appoint electors to the Electoral College. It reads, in part,
Each state shall appoint in such manner as the legislature thereof may direct, a number of electors, equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. The Congress may determine the time of choosing the electors, and the day on which they shall give their votes, which day shall be the same throughout the United States. The clause separating these two paragraphs describes the original manner in which presidential electors were to cast their votes for president and vice president, a procedure which was slightly altered in 1804 by the passage of the 12th Amendment. There is nothing in the Constitution, or for that matter in federal statute, that requires states to conduct a direct popular vote for president or for presidential electors. The manner of choosing presidential electors remains a matter for each state, although all states since 1860 have employed the direct popular vote for presidential electors. Before that, however, several states chose their electors by a vote of their state legislature rather than by popular vote.
Did you get that? The states determine how the president is chosen from their state. The term popular vote references the use of the people to select electors, not select a president. Electors are pledged to a specific person for president. Voting for president in this country is actually voting for a person to cast their vote for president. The popular vote is for electors, not the president. The misguided and totally criminal plan to count a popular vote for president as a vote for the president is not only flat out wrong, it is unconstitutional. The 12th Amendment set up a method to select electors.
The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president, and they shall make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president, if such number be a majority of the whole number of electors appointed, and if no person have such majority, then from the persons having the highest numbers not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately, by ballot, the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president whenever the right of choice shall devolve upon them, before the 4th day of March next following, then the vice president shall act as president, as in case of the death or other constitutional disability of the president. The person having the greatest number of votes as vice president shall be the vice president, if such number be a majority of the whole number of electors appointed, and if no person have a majority, then, from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States.
Set up by the Constitution, this federal union has never conducted an election for public office. Never. It is prohibited from conducting elections, as that power resides only with the states. And here comes the deception created by Democrats. The definition provided by a search for requirements to be a democracy results in this.
Democracy requires a system where the will of the people is the basis of government authority, realized through free and fair elections, popular participation, and the protection of human rights.
No. This nation, this union, this republican government is by the rule of the states.
Democracy is literally rule by the people.
But that is not how this union, this republic is established. This union is ruled by the states. The people rule the states. Democrat lies to the contrary do not make this nation a democracy. Notice the requirements Democrats have concocted for a democracy are actually what this country's Republican government creates. For the most part, they are not in existence anywhere else on earth but here.
Core institutional requirements. Free and fair elections. Regular, universal suffrage with secret ballots, allowing citizens to choose and replace leaders without violence or fraud. Performed by the states, not this country. Rule of law. Laws apply equally to all citizens, including leaders, enforced by an independent judiciary that limits government power. A uniquely American concept, derived from the Magna Carta in England, but do you recognize it in the UK today? Civil liberties. Guarantee of freedom of speech, press, assembly, and association, enabling an informed electorate and active civil society. Such freedoms are, for the most part, only existing in this union. Civic and structural elements. Political equality. All eligible citizens have equal rights to participate in politics and access public service. Try that concept in any democracy on the planet. It doesn't work that way but here. Minority rights. Protection of individual and group rights against the tyranny of the majority, ensuring diverse voices are respected. Try that concept in any democracy on the planet. It doesn't work that way but here. Transparency and accountability. Government actions must be open to scrutiny, with mechanisms for citizens to hold officials responsible. Try that concept in any democracy on the planet. It doesn't work that way but here.
What Democrats have lied about for years is a protection of their brand. Democrats equals democracy. We must save our democracy means keep the lie they have lived by. It does not mean a thing to do with this actual Republican government. But do you see any Republican claim what this country actually is? Democrats absolutely hate the idea that the states are in charge of this country through their senators and the people through their representatives. Power cannot be consolidated into total control unless that line is blurred into oblivion and the people are convinced, through repetition, that the states do not matter and the popular vote means something about the elected president. The popular vote is for electors, not a person. It is the very unique and literally brilliant Republican government created by the Founding Fathers. It should benefit Republicans, but not one of them understands the power of a brand, even when they own it. In this, the 250th anniversary year of the creation of the most unique form of government on the planet, it is necessary to know what citizens of this great country actually live under. If only to protect them from the ravenous wolves that are the Democrat Party.